o'clock. We'll call this work session meeting to order. Clerk Slater, please call the roll.
Trustee Rissy.
Here.
Trustee Nordhook.
Here.
Supervisor Lestrance.
Here.
Treasurer Corstange.
Here.
Trustee Nordike. Trustee Shipley.
Present.
And Clerk Slater, please.
Their motion and discussion or motion to approve today's agenda.
Shipley makes a motion to approve the agenda as presented for the special work session.
Support. So motion by Trustee Shipley, supported by Treasurer Corstange to approve the agenda. All in favor?
Aye.
Opposed? Motion carried. Article 3, public comments. Now is the time for any public comments on the zoning amendment process.
Madam Supervisor, a quick point of order.
Yep.
I have a hard stop at 5:30,
Okay,
just to put that on the record. So if I get up, I'm not being rude, but I do have to go.
got it. Thank you.
Yep.
Public comments, welcome on this issue. Please state your name and address for record keeping and limit your time to 3 minutes for the fairness of everybody.
Doug Lee, 6860 Cascade Road. I kind of want to put things in perspective because it's easy to make decisions. And by the way, I had to do a build out of the old the old zoning code with the Cascade location. And it was extremely restricting, as well as the current one that I've seen to have copies. It's still restricting. I happened to have the opportunity to be in Ada as it was going through Ada Vision. So I had a building in the Ada Village. Okay. And then the new part was built and that became the shiny new penny, and everybody went down there and became a ghost town in the old village because it was stagnant. It didn't change. People want cool things. Okay. But it's all about economics. So if I were to, and I'm just going to swag some numbers here. Okay. If I were to put up say a 15,000 square foot building, okay, and I were to not be lavish, it cost about $4 million. Okay. The payment on a $4 million, if I go to my bank, is almost $27,000 a month. That's what my payment would be. Okay. Now, if I put let's just say I put 6 rental properties, and I don't know, I don't want to get elaborate, but let's just say they're $1,500 a month. Okay, which I think is really high for rental in the first place. But that rental property, there's only about $7,200. And if I put 5 businesses and I charge them each $3,000 a month, that's $15,000. So if I take my $15,000 plus my $7,200 that I get, I can't build. It's just simple economics. You can't make the numbers work no matter how hard you try, because you're not going to make a $4 million investment in something where you lose money every single month. Okay, that's why Cascade is stagnant, because we have old buildings, no builder, no developer, no investor wants to invest in here because you can't make the numbers work. All I'm suggesting is we create a thriving community. We rethink this whole process to make it economically possible for developers. Otherwise, we're just getting the same thing. Nobody's going to want to do anything. We're still going to have the same thing, same problem 10 years from now. I'm just suggesting that you rethink the entire model that you're come up with. Thank you.
Hello, I'm Julie Rockwell, 1868 Sterling Oaks Boulevard. And I'd like to reiterate, I am a resident of Cascade Township. I've lived in Forest Hills my entire life. I graduated from Forest Hills Central. I have many friends, neighbors, and colleagues who work in the community. I also work in real estate. I felt that with all the people who've come out in real estate who are residents in the community, it's been a little bit dismissed, and that somehow real estate people coming and speaking out of their concern to their property values, their neighbors' property values, their colleagues, their clients, that somehow that's a self-serving thing. And I thought more about it, of the people that we help, and the things that we do for people. We see people at their best and we see them at their worst. We see them when they're divorced. I was out this weekend with a family with autistic children who were trusted to me. It's a very special relationship we have, and we have a fiduciary duty to those people. And it isn't just a one transaction thing. It goes on from there. I want to thank the people who stood up last week and committed that they do want to hear from the residents, because it wasn't feeling very much like that there was a desire to hear from the community. And I was thinking about some of the things I don't know Trustee Shipley or many of you trustees very well at all, or the staff, but I was inspired by the words he said and the passion he spoke with being a firefighter, and all the passion and that he spoke about from the commitment forward towards making sure the community is safe. And I was thinking that's something, his passion, his background actually adds to our community and adds as being a trustee. So I think when we look at the residents who are here standing out, screaming the alarms of some of the things and the values that it'll hurt for the people in this community, I think instead of feeling that we have to be disparaged as part of the real estate community, that we should actually have some sort of integration with the group that's here. We're looking out for clients and our families and our friends, and somehow that we draw on the inspiration that Trustee Shipley has brought to this group, and you all bring from your different backgrounds, and try to work together to make sure that we protect the residents and their values in this community. Thank you.
Hello, Scott Van Zalken with 2570 Orange. I want to start by thanking everyone who's worked so hard on updating the zoning ordinances for Cascade Township. This is an important step for the future of our community, and I fully support the proposed changes. I truly believe the board and everyone involved is focused on what's best for Cascade, both for residences and for businesses. Some have voiced concerns that these changes might somehow harm the township, but none of us can predict the future. What we can see is that Cascade is taking thoughtful, proactive steps to maintain high standards and prevent overdevelopment in sensitive areas. That's something that we should be proud of. It's also important to remember that zoning ordinances aren't permanent. They can and should be revisited over time. If these updates don't work as intended, future boards elected by our community can always make adjustments. I'm confident this plan will benefit Cascade in the long run. Affordable housing is another concern that many people have raised. Cascade has become an expensive place to live, and that's a real challenge. The township can help encourage more affordable options, but there are limits to what local governments can do. Developers naturally build where the profits are, which usually means higher cost homes. True affordable housing is difficult when the market doesn't support it. Still, I hope the board continues exploring creative ways to support a wider range of housing options, so working families can continue to live here. I also appreciate the effort to preserve green space in new developments. It's important that Cascade doesn't lose its natural beauty to nonstop construction. And I support the decision to move away from additional planned unit developments. The situation years ago at 1701 Spalding showed what can happen when projects start and stall. Trees lost, land disturbed, and no proper reclamation. Growth is good, but it needs to be well-planned, timely, and respectful of our environment. Lastly, I want to acknowledge Supervisor Lesperance. Some criticized her comments at the last meeting, but I commend her for speaking honestly about potential developers. Her words may not have been perfectly polished, but they reflected genuine care for this township. She's not a career politician. She's a neighbor who wants to protect Cascade just like the rest of us. This board is working to make sure Cascade grows responsibly, balancing progress with preservation and keeping our community a place we're proud to call home for generations to come. Thank you.
Article 4, new business, the zoning ordinance amendment. Manager Smith, we'll kick it to you and you can walk us through the
Okay.
work session.
Thank you. So this was postponed from the last meeting, so we could go back and do some more work on the density in the village and also get some clarification on some legal language that's presented in the zoning ordinance. So before you have a lengthy memo from planning staff, but I just wanted to highlight the two areas that we really walked away from the last meeting to come back to you with answers. That is the form-based code density, and then also that legal provision, which is number 5 on page 2. Going to exhibit B, which is on page 8, that has all of the village bonus structure that's being proposed. Again, when we say proposed, this is something that Andrew worked on with McKenna, And it's clearly at the direction of the board that they went, put this together, so it's clearly draft language and, but it's set up for some good discussion. And then Mike is here tonight to talk about the, legal language and the non-conforming provision. Everything else that's in the memo were things that were agreed upon as a group in the last meeting.
We go over the legal provision first, since Mike's gotta leave at a certain time. I don't think we're gonna keep you that long, but
5:30.
okay.
I have 5:30 cut off too. Just be hanging out with Chris.
Let's do that part first. Unless someone has an objection to that. So that would be where in the memo?
Page 2. Number 5.
Okay.
So this was the language that was, there was a request for, I believe, I don't want to quote the wrong words, but I think act of God, if something happened to a business, could they rebuild and be non-conforming? And I think that there's some issues with that. So I think the language that the attorneys came up with is what's highlighted there in yellow, which has been incorporated into the current draft of the ordinance. But I think there's more discussion on that.
Mike, you wanna walk us through this?
Yeah, so we revised the language in order to get parity between what I view as destroyed or damaged building, right? Beyond a certain percentage, where in that case, it's likely not very salvageable at that point. And so then it sort of equates it with what you might otherwise expect from a vacant parcel. Right, and the problem with, there are a couple of problems, and I detailed that in the memo to the board. There are a couple of issues. One is giving favorable treatment to existing structures as opposed to, say, vacant property owners who want to build. One, complying with the requirements of the building versus the other that may not have to. And this is apart from any use issues, because there are non-conforming uses, non-conforming structures. So just taking a look at the structure provision, if it's destroyed, it puts it on equal footing then with somebody with a vacant lot, where they would come in, propose a building, you would expect they would meet those requirements of the zoning ordinance for building materials and layout. That said, there's a provision in there which would also enable the ZBA to grant various variances if needed in order to rebuild at that location, because of the non-conforming use provisions and structures generally allow some rebuilding, not all the time, depending on which zoning ordinance you're looking at. All of that said, these building requirements are a policy issue that are best left to the board to decide whether the building requirements in terms of materials and facades are appropriate or not. I don't touch on, because those are policy issues, not. So under this language, the uses would continue, could continue. But if it's destroyed in excess of 60%, then you would have to meet the new requirements for the building reconstruction. That's how it's drafted.
Is that a common amount?
Actually, common is 50. So, but there are some cases that the courts have decided, one in particular, which was in Livingston County, where the court declined to uphold this 50%. But it's sort of a one-off, not necessarily binding.
Madam Supervisor, can I ask a question? Thank you. Hey, Mike. I've been thinking about your memo, and I think of it like the percentage is a scale, and I have equal protection and I have inconsistent application. Is that a fair
Yes.
analogy? And so I think as we move that, we need more equal protection or less inconsistency with the application of the law. I looked at other communities, Livingston was one of them, and I'm trying to find a workaround, because this to me is a pretty big deal. I've made commitments to business owners that do not want to conform. And I'll give a quick example just for those who are interested. JT's wants their parking by the street. I know that that is not in line with what we want, but they want their diners to be able to look out back. They made a big investment there. So if their building were to be permanently damaged, how do we protect that? And so I looked at other communities, and one thing that I did see is a one-time rebuild as was. But any future altercation or expansion would then follow under the FBC standards. How would that balance? Because it is one time versus. You see where I'm going with this?
I
Because
do.
I'm trying to balance that scale, and I don't know if we can, so.
Yeah, and it's tricky, right? Because we're trying to anticipate future claims from others unrelated to that particular one.
Absolutely.
That would say, well, wait a minute, why can't I build with these materials in this form or fashion where this person gets to? And that's where you may open the door to saying they are not similar, right? Because equal protection applies to those that are equally situated. And so if you draw that distinction and say, well, this is what they're building the formate or the site plan looked like, we changed the ordinance to now require something different. And therefore now they're dissimilar than these others who have the opportunity to build from the get-go, utilizing the new standard. That said, you never know how that will turn out. Like, I think that even under your current draft, the ZBA could deal with those situations on those types of bulk requirements, setbacks, site plan layout, where you could modify that to come up with something on an individual application. And it's hard to guess in advance what it might be.
The wording as you've got it right in this draft would give the ZBA that authority arguably.
Yeah, so they would grant variances related to dimensional requirements like area and bulk requirements and maximum setback requirements. So some of those might come into play in that example involving, say, JTs. As I understood it, one of the big issue was the look, since we're dealing with a form-based code, the look of that structure may be even greater given this language than the placement of that structure.
Sure, and that's why, again, as I looked at these other communities, I've seen one-time rebuild as was, but maybe that's not a direction we want to go. I will say, for me, this is very much a red line because it's something that a commitment that I made to these business owners. Now, it may not be at the direction of the board to do that, and that's fine. I just want to be on record that this is a pretty big one for me.
Chris, what about the language that this proposed language you think doesn't go far enough?
No, I'd like to see 100% destruction rebuild as was, because I don't know who will be sitting on that ZBA. And the consistent feedback that I've received from the businesses is that they've had inconsistent treatment from various boards at various times.
Yeah, I've heard that.
Well, I think you've seen it.
Yeah.
So that's my concern with leaving it to one of our bodies to deal with it, because I don't know that they will be as consistent as we are being here.
Okay, but then legally, can we do that?
I don't know that we can. I know other communities have, but I don't know that would work for us with our form-based code. So that Mike said it, it's very much a policy thing, but I think he is telling us, well, I don't want to put words in your mouth, that we are leaving risk if we do that.
So I have a question. Is it? I think before, and Mike kind of said this too, I think before it felt like the problem, the concern was that they didn't want to build to the form-based code, like the design features, but now it sounds like maybe it's more the setback requirements.
I think they would like to rebuild as is. So it's a non-conforming thing more than just the.
Because I was just
code.
wondering, because we have the the setback in the village that if where they change back, what was it? Sorry, just something about the parking lots in the front that they would be able to continue to allow them.
Not in it, because they would have to, if it was destroyed, he just equated it to an abatement. So if that were to be the case, then they would have to, and again, don't want to put words in your mouth, but rebuild following new, all the new form-based code, as well as is what's dictated in the ordinance. So in what we're proposing, they have to have between a 10 and I think 20, right?
Correct.
So like, that wouldn't allow for it to be as it is, which is fine, it's just that's the issue.
I just think it's, because we do have expansion, this is kind of a broad expansion of non-conforming buildings, it's number 4, does not require removal of existing front yard parking.
But greater than 60% destruction would under the current
Right,
division.
but that's what I'm saying, I'm
Yeah.
wondering if this somehow, you might not even think that that's probably.
If the board said, well, let's take out the 60 and just put, if it's, completely destroyed, I'm okay with that.
The not requiring the front yard piece.
Well, I think, Chris had referred to 100% destroyed, then you've got to meet this requirement. So like for the way it's written right now is 60% or greater. So if it's like 40%, you can rebuild as is. And 60% or greater, talking about moving that to completely destroyed. Anything under than that 100%, then you could rebuild under the existing footprint, existing
wall.
standard.
Right.
You're okay with that?
I'm
And then
okay with it.
the
It's-
gray area.
It's a
completely
policy
fine with it?
choice
Right.
for the board. Legally, I think it's fine. But I'll leave that to the board on how you want to deal with that policy issue.
You like that, Chris? Or how were your thoughts on that?
I mean, again, if it's destroyed, although who makes the judgment, Mike, if it's 100%
Like
destroyed?
one wall.
Should you,
destroyed,
and
one wall
and on purpose, you leave that out so that we talk about, like, to give the,
Yeah, I remember reading something in the ordinance, I thought about the value of it. So usually it's tied to assessed value,
Right.
usually.
Is that improvements or land and improvements?
Usually just the improvements.
You
'cause
see
the
where I'm
land
going
has
there, yeah.
lost it,
Yeah,
Typically. Not in a fire anyway.
right.
Unless a sinkhole opens up, I don't think we're talking about land value.
Right. No, it's just an easy way to.
Yeah. Yeah.
So if a tornado came through and wiped the building off the site, but the parking lot was intact, the improvements of the parking lot would still be considered.
We're just talking about land value, building value,
Right,
building value.
that's
So
the issue.
Parking lot is not part of the.
not generally.
Okay.
Although it is incorporated the improvements are incorporated into the assessed value, right?
Right.
So to some
That's why I
degree,
asked that.
yeah, to some degree, yeah, I suspect it would be.
And I get that this perpetuates nonconformities and I appreciate that. I'm just trying to balance that. And we do want to get to a point where we have 100% conformity. We wouldn't be passing this if that wasn't the case. But I'm trying to balance that with the needs and again, the commitments that I made to these business owners from my perspective, like, how do we serve them? And so they aren't being left out. And
And just as a practical matter,
yeah,
you'll never get to 100% conforming in the township.
sure.
Right?
But
Yeah, the goal is always to eliminate them over a period of time.
yeah,
or to, and I don't think that's yes, but no, this is really not to eliminate it. It's just to encourage when redevelopment does happen, the right kind of redevelopment and not get more of the same, which right now you could get.
well, we don't want inconsistent character either. Like you've done a lot of thoughtful
Yeah.
thinking with trying to get this so it looks nice too.
Right,
But
but
to differentiate it from the rest of 20th Street as it creeps.
But I do
Yeah.
think one of the good things about our form-based code is it is set to incorporate our current businesses as well. So it doesn't look obvious that like, oh, this one's obvious a new one and
Yeah.
this one's obvious an old
Mhm.
one. I think that was
It's
one
not
of our
going
big
for like a uniform.
questions with McKenna was to make sure we could put something together that didn't look ridiculous in the, when you're driving down this area.
I don't have a problem getting as close as we can to honoring that, representation of individuals, as long as it's legal. And we're not giving a windfall to certain property owners compared to others, but so if you guys figure out a way you want to word it that's legal approves, I'm fine with it.
I mean, is there a way to get there if it's completely destroyed that they can rebuild it as it was?
When you say, so I want to make sure I understand it. When you say rebuild it as it was, are we talking about updated building materials or site plan layout? Cause I think there's a difference.
I agree with that. I think site plan is where I'm looking, like if it's. Again, I'm even fine with it following the new facade requirements, but the placement of the building, so I guess that would fall within site plan,
Yeah.
you know. So
Yeah,
that-
I think we could tweak the language to allow rebuilding in the same configuration with updated building material.
Yeah, I think that would get there. Let me look through it and how it would come, but yeah, it's getting closer, certainly.
I think that would be helpful. I think one of the things I hear from the business owners over there, and I haven't talked to JTs as much as you have, but some of the others have made reference to me that they like the appearance of the parking in the front. And I think they're afraid to lose that because they view that as a marketing technique in a sense. You know, if you drive by and the parking lot's full, you know, well, it must be good there. I want to stop by. Whereas if you drive by and the parking lot's empty, you know, you're not as inclined to visit. So I respect what they want from a business standpoint. I see that. And if they rebuilt and had to move all the parking in the back, they view that as a negative. I'll have to mull this over a little bit since it's fresh off the press.
So are you gonna put something together then, Mike?
Yeah,
that we can
I'll
look
go back in, tweak that language and then distribute it to Andrea and she can then forward with you.
Thank you.
Can I ask Mike another question before she goes further?
Yep.
Sorry, I'm bringing this up again, but I brought it up before. In 14.3. This is the planning director's power to grant PUD amendments. The draft references the zoning enablement acts, and Mike, I worry that the planning director has extensive powers that could be interpreted as administrative rezoning, which is absolutely not authorized under the MZEA. Do you have any concerns as you look through some of that, like that? Because rezoning decisions must go through the legislative process, which is our planning commission recommendation to board adoption. This seems to circumvent that.
Depends on the amendment,
Okay.
right? Like if you were amending a PUD to completely change or maybe even add a use, I could see where you could reach that conclusion that you're circumventing notice, public hearing, opportunity for comment. There was a recent Court of Appeals decision that I was involved with. The argument was similar in that there was a text amendment. The text amendment added a new use in a district just by text that then was challenged on the basis of it constituted a rezoning. That you are now fundamentally allowing uses in the district that weren't otherwise provided, and you're doing it as a text, and it has to do with the impact on notice, right? One, you just have to publish, the other one you'd have to mail. And it makes it hard to mail notice because it covers everybody in that district plus within 300 feet of that district. So the Court of Appeals ended up upholding the lack of notice in that context. But if you were doing this as an already established PUD and then adding or changing to the uses, that could be problematic in terms of avoiding the public hearing and notice provisions. I think too that if I recall correctly, the Zoning Enabling Act says that you can attach those, it's sort of like almost like a special land use, where you can attach conditions to that approval. And once you establish those conditions, they become part of the record. And then they cannot be revised or amended absent the landowner and the body or person charged with approval of that. And so if you equate it to sort of those standards relative to special land use permit, you're now delegating that authority to the planning director to do. And so I'd have to look a little closer at that issue, but I also see that as a potential issue.
It's just something that I think it would be good for you to look at, because I do worry that it could be viewed as circumventing that. So I don't know that it was intended to be that, but it's something that concerns me. And then the other thing that,
Do you want to give him the number again, just to get his homework?
yeah, it's 14.3. Starting with D. And then it goes to 14.11.h1. And again, I think it could be interpreted as administrative rezoning. So again, I'll defer to your judgment on that. And then,
Can I just clarify something, Chris?
Mhm.
So you're saying you're questioning PUD amendments being made by the planning director?
yes,
Okay. Well, look at the language, but the chart actually took that away. That was one of the changes we made.
sure, but it still states it in 14.3D that it's very much, so chart may take it away, but
No, I understand.
language says that it's there. Last thing I have, then I shut up on the legal stuff. The Village Design Review Committee. It's unclear in here as it relates to the form-based code districts, whether the Village Design Review Committee's recommendations are binding or advisory. The ordinance calls it a working partnership body, but if you look at table 14.2.a, it still lists both committees as review steps for certain applications. So this dual review could lead to delay or procedural disputes. Like, is it one or is it the other? Have we given that thought? Like, who approves? Where does it go? Is it, like I said, it's silent on whether it is advisory or if it's going to deliberate and make a decision.
What is it in the current zoning? Because this is a carryover.
Advisory.
Did we do anything to change that?
We did, it's silent. It just says working partnership body.
Okay, because my understanding from that it is advisory, but
And let's just say that, that's all.
Where's that in the text? Page.
14.2.a is a table.
And it's
and
elaborated.
again, this is
chapter
in the
14.
old zone. This is nothing new.
Yeah, I'm not saying it is. I'm just saying we have an opportunity to be specific. We should be.
It does say in item J that the VDRC is required to render any recommendation to the planning commission.
But then it's,
But that doesn't,
No, I understand it doesn't.
that's just
It
process.
just says that that's the process. They're gonna make that recommendation, but it doesn't say that everybody has to. Yeah, it doesn't say how.
is it advisory or is it
Exactly.
binding?
It doesn't say.
The section 14.6 C4 says the applicant shall incorporate the comments and recommendations from the VRDC into the site plan application prior to the planning commission review of the site plan. If a comment or recommendation from the VRDC cannot be met, the applicant shall include an explanation to the planning commission as to the reasons why. And then the planning commission would make.
I see all that. we need to be specific. Is it a binding decision they made
It is not.
or is it advisory? Then let's say that it's not.
Needs to be a line item under 13.5 that discusses that thing. In the section prior to 14, where it talks specifically about the Village Design Review Committee.
What page is that?
That is page 13-208.
225, is it? Yeah, 225, Grace.
Oh, am I on the wrong page?
She's looking at the PDF, which is what I'm looking at, so.
You're on, which one are you on?
She's on the PDF, so she's looking at the electronic pages.
Oh, sorry.
This would be the draft version, October 23, as explained in the memo. You're looking at the draft version, October 1.
Okay, I'll switch back.
We can update that to clarify that.
It'll protect us, that's all. Like, it's not.
And I can't, from looking at this, and it's been a few years, I remember reading it because we had to appoint the members and thinking it was advisory based on what I read. Having said that, I don't remember the exact language, so.
That would be in
either add it
chapter
or
eight.
or maybe we're not seeing it right now, but either way, we can
I searched it and then I had the machine search it. I couldn't find the words advisory or binding.
Okay, so note on that, because I think we all agree on what the intent is, and it's the same as it has been since all of us have been here and before.
Not that anybody would sue on an advisory committee receiving that it's binding, right, Mike?
You'd be surprised.
I know.
Depends on what they want.
Yeah, I know, that's, I can think of certain people who live by a park who would absolutely do that, so.
Okay, so we'll look at that language. I'm just reluctant to do it quickly or to be too specific, because a lot of times language is there, it just might not be the exact word, and then when you add something that kind of has unintended consequences, but we'll thread this needle. Okay. Any other questions for Mike while we've got him here? Mike, anything you want to talk about while you're here?
No, I think I'm all set. I love JTs. My kids love JTs. I can't get away from JTs, so.
And they can stay at JT's as long as they want, in the same exact position.
This morning.
Good.
Mike, while you're here, it may be helpful to talk about process and procedure as far as introduction and adoption of the ordinance and any changes that the board may want to make in between the introduction and adoption. Supervisor Lesperance, if that's okay with you, it may be a helpful topic.
So at this point, you follow the same process as you would introducing and adopting any other ordinance. So you've had the planning or the public hearing at the planning commission, they've made a recommendation now to the board. What that means is that you sort of combine the zoning enabling act along with the charter township act, which requires you to submit it for what's generally called a first reading. But it's just an introduction of the ordinance, and then you get to an adoption of that. And so you've got to post sort of the notice of introduction and when you will consider it for adoption. The Zoning Enabling Act also has a provision in it that says that if the planning commission recommends something to you, you can adopt it with or without amendment. So there is a limit to that, not in the context of an entire zoning ordinance, but rather other amendments, like, for example, if the entire ordinance was not subject to the notice and public hearing. I'll give you an example. Let's suppose you were talking about amending the zoning ordinance for private roads. And then it gets to the board level and you say, oh, I also want to throw in this provision for non-conforming structures. Well, that's problematic because the public hearing didn't encompass that type of amendment. And then you'd probably have to refer it back for another public hearing on that additional amendment. So, but at this stage, since you're doing a complete readoption, then you're free to make amendments as you deem necessary at this level.
Is it appropriate for the board to reach out to a certain group of residents or certain group of property owners? Like schedule a meeting with a small group or certain people, or do you think it's better to just, as the board, notice it out to to get feedback, to solicit it from a targeted group who may say they want a special meeting, or just to continue with noticing out to everybody who would have received notice to keep it fair, so that.
Yeah, and sometimes, it happens quite frequently where, board members either reach out to constituents or constituents reach out to board members. Neither one is prohibited, so I'll let you decide. What happens sometimes, though, is the whole board doesn't get to hear verbatim what's being discussed.
But I mean, at the township level, right, like on an individual basis, or even on a couple of the trustees, but I mean, as the board, as acting on behalf of the township as a whole, to reach out or have a meeting with a certain group of residents or certain group of property owners, soliciting their feedback, but not.
Can I give an example? So like, for instance, we're changing the B1 zoning to the form-based code. So if, so B1 is going away and then it would be, eventually it would be these different codes. Is it appropriate to engage the people, the owners of the B1 district as a group and get feedback from them on this process, as opposed to inviting everybody in the township? Because
Or just doing another public hearing where the notice goes out to the notice goes as required by law to anyone affected and within a certain number of feet.
Yes, you can either do that formally by saying we're gonna hold a public hearing,
Mhm.
or you can just invite them and put it on the agenda. Because another public hearing at the board level is not required.
Right.
So can you seek input directly? Absolutely. There's nothing legally prohibiting that. It would be done at a public meeting regardless, so the public is able to be here too, and you utilize public comment in order to comment on that.
For the village design review. I think it's worded enough. Tell me, Mike, what do you think? That VRDC review. The VDRC shall review the information provided by the applicant. The planning director shall forward all comments and recommendations to the VDRC, to the applicant and the planning commission. The applicant shall incorporate the comments and recommendations from the VDRC into their site plan application prior to the planning commission review of a site plan. And then here's the key sentence. If a comment or recommendation, so comment or recommendation from the VDRC cannot be met, the applicant shall include an explanation to the planning commission as to the reasons why.
Yeah, and I think, you know, when you read, and I wanna make sure I have the right version, because I have a next letter D. And D talks about standards for approval.
Yeah.
And part of that is the VDRC shall review all applications for consistency with the provisions of the form-based code. So if they are simply commenting or making recommendation, then I'm not sure why this is labeled standards for approval. What are they approving?
If they're advisory, they're not.
Correct.
They're making a recommendation, but they're not approving anything.
So do we take out D?
Could take it out, or this is where I found the conflict, right? Because if they are an approval body, that's one thing. And
that's why I think in section 13.5, it should explain that they are not an approval.
right,
I think that's where it should be, not in section 14, where we're talking about the specific site plan. I think that's right, the process. We have a whole section on the village design review committee in section 13.5. Or at least we did in the October 1st version. Still scrolling, I know.
I like the standards for approval of the language, basically giving that committee the direction on to kind of what lens to look through. The impact of the improvements on neighboring properties, benefit proposed improvement to the community.
Yeah, I think you could just add a couple words in this section to make it clear that it's making recommendations only that are not binding on anybody else, including the board.
Wouldn't you add that to the, where it says what their purpose is?
Probably.
Essentially, right in
Yeah.
that statement.
Yeah.
Which would be letter A, I believe, on page 13-214.
Yeah, I think you could just tack on a sentence to add. Make it clear that the village design review committee comments are recommendations only. And then you gotta tweak a little of the other language that talks about incorporating those comments and then explaining why they couldn't if they can't. The applicant.
We do that, we'll send it to you, Andrea. Does that make sense? We can just.
Yep. I'm with you.
Okay.
What about, I'm sorry, the private roads? Not trying to make changes to how many, but. In 10.2H, we put language in about a remediation measure.
What page?
10.2H is 194. Do we, because again, what I've seen is like remediates a problem with private roads because we don't have a ton of authority, right? Because there were some recent cases in Avon Township that limits municipalities from compelling private road reconstruction unless it's tied to a new development. We want to be clear that this is relating to a new development. Or do we want to tie it to a public safety compliance, right? Because now all of a sudden we're not fitting either of those things where like that township lost. And if we want to compel these things, I think we need to be specific. And again, Mike, you may have a different opinion on that, but you see where I'm going with it, right?
Yeah. Yeah. Yeah, it's really the expansion or extension of.
I think we could get sued very quickly for that. And again, I think Avon lost.
What's the section again? I don't, you said it, I'm just not finding it.
No, that's fine. It's 10.2H. Township may require remediation measures if an existing private road serving additional lots is found to be inadequate for emergency access. And maybe that does it, but like, I think.
There you go.
Yellow, oh. Within the maintenance agreement language?
Yes. And like, maybe it's as a condition of new development approval or a lot split on a private road, the township may require improvements necessary to ensure compliance with the emergency access standards.
I think something you just said is important too. It's not just expansion, it's like lot splits as well. Because
Absolutely.
I know we've
Mhm.
had them in the past come. And the fire department was really concerned with the roads as their current state.
Yeah. I just don't like us implying that the township can unilaterally.
We can pick
order
at any time to do.
Right, because that would exceed the zoning enforcement powers.
Right.
So I don't know, Mike, if you want to take that and look at it separately, like that. You see where I'm going with it.
Yeah.
I see why we put it in there
Yeah.
after having to deal with it always.
Right. Well, and I was trying to figure out too, if at the beginning of that section 10.2, if it stated up at 10.2, these were only for expansions or.
You just have to make it somehow connected to compliance with emergency access standards somehow, some way.
But I would think that it would have been in the beginning.
Wherever, and that's where I think Mike can probably give us a better recommendation where to put it.
Madam Supervisor, may I ask a question on a different subject? Let Mike finish typing here, so. So, 4.63. Section 4.15 D3. So I'm scrolling there quickly. 5 D3. talks about,
43.
it talks about maintenance of sidewalks,
Yeah.
and one of the things in there, it refers to as snow removal. The township really handles that in most of the village area and things. And I'm wondering if we are, by specifically putting it in there, but if we're doing it, there's no metrics as to what is required of you. With regard to, you need to shovel your sidewalk if there's 4 inches or more of snow, or it needs to be, ice-free at all times. I mean, there isn't any substance there. Is that a concern, I guess? That we don't, or should,
That it needs to have specific,
does it need to have
is that
specific
enough?
specifics, or is that enough?
And there was no former, just to, you touched on this, but there was, it's unusual that the township just, its mowing policy and snow shoveling policy, like just handled all of it in a small area. So I think the goal is to go back to what communities normally do, which is if you're the business owner, you maintain the sidewalk.
Yeah, because bringing the buildings up to 4 feet of the sidewalk, it could be snow would have to be trucked out. That cost quite a bit of money. So village shouldn't bear that cost because the building owner brought it right up to the sidewalk with no room for snow.
That's a valid point.
That seems oddly specific to me.
Yeah, but you'd be surprised.
Happening in Ada. They actually have to truck it away.
Truck it away.
So how specific,
the
because in
best
general, do you need to be more specific in language, or can it be one of those, I mean,
It depends, like, so I'll ask this question. I presume you've had a similar requirement previously. For clearing sidewalk?
We did not.
I don't think we did,
We
which
had
is
to-
why that was part of the problem, and then it was just a gray area.
The township clears the sidewalks, and in fact, contractors in town have been told to stay off the township sidewalks, which is part of the problem here. Is that they've been trained to avoid anything in the downtown development area because the previous director of that department, not in previous staff that isn't here any longer, instructed them that they are not allowed to clear the snow there.
So I wanna make sure that, cause I did not read this provision to be applicable to only a certain area.
And I don't believe that it is.
Okay.
I think it just applies to, I mean, we still maintain the pathways, correct? We're not. Pathways are different than sidewalks.
Well, but the way this is worded, it's treating them both as though they're the same.
Which
And-
spot, Scott? Cause I haven't
On
found it
page
yet.
74.
74, thank you.
Yeah.
What, 74?
No.
It could have yelled when I
74 of the
said-
packet, page 4.63 of the October 23rd draft.
Where,
I think he's at 4.1.
D-
sidewalk. I-
D3
assuming this is where-
Says materials and maintenance.
three, there we go.
And it says the property owner shall be the sole responsible party for general maintenance and upkeep of sidewalks. So I guess that would be a reference that it's not inclusive of pathways.
And we just do maintain the pathways. I don't read that to mean that we're absolving ourselves of that.
But in the DDA clears the snow from the sidewalks.
No, that's DDA is the township. That's just where the DDA funding, who pays for the township is, the DDA is the township. It's a district,
Right.
but,
But they currently clear the sidewalks of snow within the
but it's our
DDA.
buildings and grounds crew, the same crew that does all the work throughout the township. The DDA is not, the DDA and for this purpose, the DDA and the township are the same thing for snow removal.
I agree with you.
And we're trying to get away from that because it's unusually weird and unnecessary that we would just cover that for all businesses.
I
So
guess
that
what
if we
what
put it in there specifically to change that.
Right, I guess what I'm getting at is that there is no metric or standard as to what is supposed to be done. And currently, and in the past, the township has done it. And now we're saying in the ordinance that the property owner is responsible for it. So let's pretend for a minute that the DDA cleared the walk in front of a business in the right of way and somebody slips and falls.
Then you got the most litigated issue you can imagine, and it's gonna be like. I mean,
Happens every winter.
Right.
This is like, welcome to
And
Groundhog Day
everybody
of being a lawyer.
Feels issues and opinions saying, yes, you should expect ice in the winter in Michigan.
And then it's just to wait to see how the
It's sort of
Supreme Court is
sort of
policy.
open and obvious, right?
It is.
Bernstein's changing that.
Bernstein changed that.
Right,
Big time.
yeah.
They did,
So-
they walked that back.
So that's the
February
clarity, Scott.
23.
Supreme Court,
And it-
that's your
Well, my question
policy.
is, in the right of way,
No.
the property owner is really
Absolutely
not
no, it's a-
affected at that point, are they? Because it's in the right of way,
No,
is that, are they
well,
still,
depending on the right of way, yeah,
okay,
yeah,
Right,
they,
no.
they still.
they
might
could
have
still
that
have one,
obligation.
okay.
But, you know, the broader issue is, so standards, I don't have any problem putting in standards. I had a client who went through this last year, year before, but they had this provision all along and they said, oh, we want to tighten our standards. And I said, well, how many tickets have you written under even your old standards? Zero. Now, whether or not you're going to enforce it, in an arduous fashion, I guess I'll let the township decide that, but it's difficult, even with standards, to then enforce, because there are a myriad of different situations, right? Are you gonna make the 80-year-old grandmother get out there and shovel her walk? And so I just caution you that we can put the standards in, but it becomes an enforcement issue.
I can speak to that as well, because by the time you get around to enforcing it, there's usually a time
weather
frame,
has
and then the
changed.
weather's changed and it's gone from 32 to 60 degrees and it's melted. And just to comment about the DDA, so the DDA is kind of, in my opinion, it's its own animal. It's there to promote the district. It's there to promote the, everybody, we collect that TIF. So if the DDA decides to fund the cleaning of the sidewalks within that district, that's something that they're choosing to do regardless of the ordinance. We're not going to do that in our industrial parks if there were sidewalks done in our industrial parks. So it's very similar to like landscaping. A lot of DDAs take on the landscaping within a district, but you're not going to do that in another area as well.
I guess I'd like to see some standards as to what's expected as, you know, as a contractor that removes snow.
Usually anything over 3 inches and needs to be removed within 24 to 48 hours.
You'd be surprised how much it varies from community to.
No, that's what I'm
community.
saying, but I'm just saying
Yeah.
it varies so much because we don't have that type of enforcement. to Get out there and do that.
Right, but I think that's important, particularly since in parts of the township, you know, contractors have been told that they can't run their equipment on, you know, on the walks, on the sidewalks within the, you know, village area.
Bizarre, I mean, that's the issue, that, the language in our zoning is an issue, the fact that someone in the past said that to them is really the issue. I don't think it needs anything, it's either us first, that's just clarifying that they're responsible, but if you guys wanna put it in, that's fine, I just hesitate to get too specific on too much stuff. But I see what you're saying, it's not,
think
it's not a
staff
deal
will-
breaker.
I think staff will need something with some teeth in order to have somebody take action, on something in the future.
I think from a practical level too, this was something that Eric had requested based on the fact that he gets calls all the time of like, who's supposed to do this? Can the
Mhm.
township do this? And we really just wanted some simple language saying, this isn't our responsibility.
Mhm.
Many of the residential developments in the township already have associations who do that, and commercial properties should be responsible for their own. And I think that was the intent with just adding this language to put the onus, to take the onus off of the township in an official way.
Like, you know,
We could
Not
put some standards in there, but I just want to I just want to let everybody know that those standards they're very, very hard to enforce. Because the minute,
Yeah.
if you say 3 inches and it melts a little bit and it's down to 2 inches, you can't enforce it.
And then someone
And
does get enforced because they're
So-
ongoingly ignoring it, so then someone says, well, what about the other place? You didn't go after them, so I would rather say just they're responsible, and if it's an ongoing issue, then you cite them.
But we can.
is there you know, I look at this, I think of Hall Street as being the only spot I can think of where there's sidewalk that isn't in a neighborhood association
That
area
is the only
or
place in Cascade
a-
that I was told by the former
or the
manager,
village.
and the reason, and that was the
And
agreement. they
residents had
wanted.
agreed to take care of it.
But again, the rules run
Oh,
with property,
yeah.
not specific residents,
Sure.
so when it was put
Right.
in, and then over time, like everything in the town, or the gray area, so people forget or people move. And then it still is it was on the residents, it was always on the residents, but the township in the past started just doing it. So then you start to create the expectation that that should be done. So then there was a woman who called whenever it snowed. That's why I learned about that. But that's the only place that has a sidewalk, not a pathway other than the village area.
I think I'm
some of the
okay with the
investment-
way it's worded, but if for some
Oh,
reason the
yeah.
DDA stopped doing the village snow removal, then I would certainly want more conditions put in there. You know, if we expanded where the sidewalks were that we were concerned with. But
If
just
we
being
did
Paul
that.
Street, I think this is in the spirit of that past agreement that it had with the previous owners there.
Okay. Mike, what else can we throw at you while we've got you here?
Well, I'm a wealth of knowledge.
I know. When do you start, when would can you think of an example when the municipality would start, it would be a taking as far as property rights? When you
Yeah.
change your zoning,
Yeah, when you destroy all economic value of the property.
all,
Yeah, all, which is a tough standard to meet. I mean, typically, it doesn't rise to that level. A lot of people use that term inartfully, you know, to say, well, you've taken away my ability to develop it for X, whatever X is. Well, that's not a taking in and of itself. It's gotta destroy all economic value of that property. And so you can think of a myriad of uses that that property could still be put to use for. And so it's a really difficult standard to meet in terms of rezoning. And for the most part, I'm talking about vacant property as opposed to improved, because improved property you can continue using in that fashion anyway.
as a non-conforming use.
Right.
Before, do you want to get, is the next issue density in different areas, or do we have anything else to knock off before we get to that?
No, I just have one general comment, and maybe it's just a frustration. I feel like at the last meeting and a half, 2 meetings, we've talked about continuing to stay on the October 3rd zoning draft, which I know Scott has in front of him and I have in front of him and other people have in front of him. And then we were given this list of things that we were getting close, and we had a list of things that we needed to talk through. We didn't talk through all of these at the last meeting, but now we've been given a new draft that has had all these things changed in it. And I think that's super frustrating when we were told that we we're gonna keep on the October 3rd and that this was gonna be the format moving forward, that this is what we we're gonna do. And now these changes have been made in here without us. This is a continuation, it feels like, of our last work session. We didn't finish the work session fully. We decided at the end of it, and before we made any board motions, that we were gonna move forward.
Keep going.
Okay, that we were gonna finish hashing this out at another work session, but then now these changes have been made and
We can go back to the October 1 and then make a motion. I mean, the board can.
I just
I
feel like
think-
this is one of the frustrations that I know we've heard from residents, and I think even as somebody who has sat through all of this from the beginning, it is hard because when we're doing works, you know, subcommittees, we're doing work sessions before we're getting to the final, but then we've been told at the last 2 meetings that we weren't gonna change the draft, that we kept going off the October 3rd.
You're not wrong, but I will say that all of the things that were incorporated into this new draft that you have in front of you, other than the density and the legal language, were things that there was consensus from the board on.
I'm gonna say there wasn't, and maybe I'm
Which
just
one?
mistaking, the removal of the requirements for a B registry.
Oh, I think, yeah,
It
we
was-
never
it was
ever.
brought up at the meeting before. Scott had brought it up. He talked about that and he talked about goats, and then we all just were like,
No.
oh.
I specifically brought up bees at the very end and you said bees are out. Registry was out. I have that written down.
Oh, I missed.
I don't want to say you, I mean, in general, there was definitely
remember that.
consensus on
I
not
remember
having.
Different, trust my, I
Yeah.
remember that.
I don't
Wait, the
remember
bee
either.
registry or no bees?
Registry.
Oh, I thought we kind of agreed. The Michigan State one is not binding and it's. not
Correct.
Like, I think we need to keep it in for
But
those.
we
people
removed the
out.
requirements for the bee registry.
So this is, we didn't want to do, question within the board members of switching our board registry that we wanted to do at the township to one through Michigan State. And we said no to using the Michigan State one, but we wanted to maintain
So
our.
I specifically remember that was the very last comment that was made during that work session. And when I said the word bees, I was shut down and said, bees are done.
Sorry,
So however that was interpreted, that was the direction that I will take the hit on that because that was the direction that I walked out of this room.
oh, no, I misunderstood or was out at that point. Or I don't know, remember that part. Can we rediscuss that real quick?
You can do whatever you want.
Sorry.
I was willing to do another registry, so
My preference is we keep the registry based on some residents who have bee allergies, and then they have a way to document that, because the Michigan State one is a great resource, but it's totally voluntary and there's no.
Right.
I just don't think we should have people in the agricultural district that are using them for crops, because the way it's written,
This is
it's
for the residential only.
right for R1 and R2.
Correct.
As
You find
know,
that.
right?
Yep.
I can get behind that.
He thinks it was not written that way, so if it was written across the board, then I think that needs to be modified to only be a
R1
local
and
registry
Too.
in R1 and R2.
So let me just read it for clarity. So in section 4.4, D, what is 3 now on page 456
Okay.
of the draft in front of you of the October 23rd.
I'm sorry,
Version.
which page? 4
Dash
4-5-6.
66.
Okay, yeah.
Section 3 was removed, which says registration required. No person shall keep bees unless registered with the township in accordance with the township bee registration policy. Is where we wanted to put that language. Then
Meaning
F-
it's taken out right now.
Can you just tell me what page it is electronically?
67.
Thank you.
Thank you.
So we're saying we
I-
are we're requiring registration?
I think
no,
we
it
should.
is, well, the draft in front of you, and I want to address the draft comment as well, because yes, I did say that for the last 2 meetings that we were going to go off these memos. But at some point, we have to move forward with this. We've been keeping a draft going of all the changes that have been discussed at all the various work sessions throughout this entire course. Our board meeting that this is to be introduced at, which I'd like to have a very clean copy, is supposed to be next Wednesday. If we don't continue to do this, we're not going to have the proper document. So that's why this one is in front of you tonight, because when we walked into this room tonight, there was supposed to be 2 items that carried over from last time. I know there's been other items that have been brought up now that we're going to also address, but this is where we're at. And if that's the case, then we're going to have to table it again from the 5th to the next meeting. So I will take the hit on both of
Well, I
those in
just
regards to
didn't
bees
remember-
and the change in memo.
I just don't remember the discussion at that point, which isn't on anybody other than me, but I guess I would, since it's up, I would prefer that we keep part 3 in about the registration being required.
Can we keep it?
What
in,
is the
but with
fine for that?
label that
How are
it's-
we going to enforce that?
I
Well,
like
that's
a strong
separate-
opinion of it.
No,
not
that's
like
a
the
separate
registry.
issue though.
But hang on a second.
No,
I think it's ridiculous that the
It's your
township's gonna create a registry for that, but that was my,
But it's been
opinion.
in here since
The beginning.
the beginning.
I know, and I've been harping about it since the beginning.
But Jade, is there an enforcement issue?
Never
Like,
heard that.
I'm being serious. Like, I sense that you don't like it, which is fine. Is it, and I suspect it's because of the enforcement, like, how do we maintain it? Is that the concern? Like,
For
what?
sure.
Yeah.
Let me ask Mike, our attorney, a question on this. If we have a registry, that, you know, if you're gonna have a beehive, you have to come in and register your beehive with the township, okay? And there's a little kid next door gets stung and something bad happens there. And we didn't update that registry. Our staff made a oops and didn't update the registry with that hive being registered, and the people moved in and didn't know it was there. Are we, do we somehow entangle us into some responsibility there legally?
Not in my opinion.
Okay,
I mean, you've got governmental immunity. I mean, and
it just looks bad.
here's the other thing.
No, I don't think that looks bad.
How are you ever gonna show a causal connection? That that bee belonged in that hive? Right? That,
Some people put dots on their
you,
knees.
you can get stung in various different places, right?
Right, no, I hear what you're saying. I'm just asking the question.
Yeah.
And the intent truly was just in the residential area, that if Scott decided to get 5 beehives and I am deathly allergic and I am looking for a home that there would be a way for me to at least look at a registry to say, oh, this house neighbor has beehives. For my safety, I just don't want to live next to it. That was kind of the intent. We had some concerns from residents when they had heard that we were going to start allowing them in the residential areas that were anaphylactically allergic, that they were worried that we were going to start allowing. So this was kind of our way of being like, well, at least if we have a registry, one, they have to come into the township and get the rules, so they understand there are rules where they have to have barriers and different flight.
Maximum amount.
Yeah. So that they would understand that. And I think the idea of the registry is really that they got those requirements, that they understand it. What they do with them is up to them, because we're not saying that we're gonna go back and enforce them, but that's what the intent was.
I think it's just busy with
So,
staff though.
I
How do
think
you
the
beat that?
management of this registry, which, I don't know, is that done by somebody in the office, Jade, if we did that? I think the management of
I think
this,
certainly.
We were thinking the trustee that's two to the left of the manager.
I think that I just think we shouldn't allow it in residential, period. That's my opinion, because I think it's gonna be an administrative nightmare.
Or take out, what if you, okay, so what if?
Well, wait, now we're headed down a path of changing the actual meat of the ordinance and
Yeah.
not allowing bees.
Two things, so because then you could say
That way, just-
registration.
like, I don't think
just
that-
Registration not required,
I'm
meaning how
sorry.
it is now.
I don't think that's where we're at. I think there was, I'm sorry, and I may be out of line, but there was already consensus to allow bees. We get requests for bees all the time.
Oh,
This is the
yeah.
thing. People want beehives.
We do.
If we want to keep this, we can revert back to the language that's in here, but it's going to create a policy. This ordinance does not define what the rules are going to be. There will be a separate policy which will then guide this ordinance.
I'll defer to the board and staff. If the registration requirement is too much or the enforcement's unrealistic, I'm fine with taking it out.
I agree with you then.
So what's the thought?
Do a straw poll.
I don't think we can if we don't have the answers to what she just said.
What do you mean?
Just throw-
No, so
What's the debate?
just the registry.
Oh.
Taking it out, or, which I'm okay with, or keep.
Okay, I'll make it easy. Mike, weigh in on this, please. Keep it in there. The policy can be not to have a policy if you want down the. If we all decide that there's not a good policy to put in place.
Okay,
Is that a question?
we're looking
No,
for,
it's actually a statement.
He wanted you just to nod and say, yeah.
You know, these are policy, not legal issues.
That's what
right?
I'm, yes.
oh, got it. I
Ordinance
get where
points
you're
to a
going now.
policy that says the township board has decided that the policy is no action will be taken regarding bees.
Yeah.
Is that
Well,
acceptable?
or the policy is that these are permitted without registration, right?
Yes.
Right.
Which does that bring us,
The same thing.
yeah, so does that bring us back to just taking out 3, which I should have just left it as is?
If you want the option, keep the language in there. If you don't,
Leave
then we
it.
can take it out.
All right, then I need to hear, I'm okay with, I see what you're saying.
Leaving it in and letting them do what they want.
I was gonna say, I'll be fine with taking it out. It's just,
I talked about.
I know, I
residents.
apologize to bring, Jade, what do you think?
Just leave it in.
Thank you.
Because down the road, if you want to actually do it, then I have to come back and amend the ordinance.
Got it.
And then I think the one
Sorry.
thing that.
No, it makes sense.
Scott did
No, I'm
mention,
sorry
though,
for
can we
catching-
just have it state for R1 and R2? That would be the change then. Is that correct?
Yeah, I figured you could say that in the policy though.
Yeah.
I like the idea of having, we'll just have it reflect the policy and we can worry about the details in the policy.
No. You're confusing the two.
Yeah.
The bees are allowed. The registry is only what's at question to allow
Yeah.
in R1 and R2.
I
The
agree.
standards for bees, this needs to stay as is.
I
Yeah.
agree.
Okay.
I'm agreeing with everything.
Okay.
But what we were saying is that in the policy, it may reference that no,
Yeah.
only properties located in the R1 and R2 are required to
Yes.
register.
Correct. Correct. I was
So,
saying we could
just to
fight
be-
that out in the policy,
Yeah.
not,
So that will be a change that will be marked as it was taken out and now it's put back in,
Yes.
into this document.
that's right.
So Jade, what were the two?
Trying to
things
use
that
up
you
that
said?
purple highlighter so that it doesn't show up anymore.
I know, I don't have any good colors.
Legal language and the village
Good.
density.
Okay, and.
We've just gone through the village, well, we've gone through the legal language
Okay.
a lot more.
I
What
think
about
what-
section 4.21 for fences? We were gonna talk about that, I think, weren't we?
Sen-
I'd asked about that a couple meetings ago.
No one
about-
wanted to talk about it.
What are we talking today, right? I thought we just didn't finish that at the last one.
Which
No, we
part?
walked out of here with,
Centennial Park.
Yeah, we needed to discuss that too. There's a few
I-
things we
I
didn't
think
get
it-
to.
Well, I
I think
thought
it's
it,
the-
I interpreted the way Jay did, but that's just. It was a gray area.
So
So let's push that off to the density part.
I think that's all we have to do now.
So fence.
Fence, so my question is, currently, we don't regulate fences 4 feet and under. Do we really need somebody that wants to build a fence in their backyard around their garden or something that's a few feet high to keep rabbits out? Do we really need them to come in and get a permit from the planning department for that?
Didn't we talk about that at the last meeting? We said we didn't. We haven't.
I don't believe we did.
Thought you said.
I brought this up a while ago, but I don't think it actually was addressed in the memo for tonight.
I thought we talked about this. before.
It was in the memo, it was addressed in a memo, but the board never brought it back up and made any decisions.
We didn't get to it.
Yeah,
There's a list of things in the other memo that we never got to, and this is one of them. So I would like us to basically say that fences 4 foot and under are allowed and not require any permit or review related to that. I think the Michigan building, I think that's consistent with the building code.
We don't.
And currently it's 6 feet and under, no permit required.
correct. So what we are adding to the current procedure would be in section 421(3). Right now, anybody builds a fence, they don't have to come in, they don't have to do anything with it. But now we would require a zoning review. Prior to the construction, replacement, extension, or erection of any wall or fence in any zone district, the property owner or their designee shall obtain approval from the planning department.
And see, I think it should say any fence over 4 foot would trigger that.
Or over 6 foot. I mean, it just seems like more
And I don't think you can
bureaucracy.
do it
I
over
think-
6
'cause
foot
I
Yeah.
think
without
4
special
feet are
permission.
allowed.
It's not allowed.
Gray area, so I
Without a
think we should
variance.
say anything over 4.
I think the reason it doesn't say 6 feet is because we want to have some say on if somebody puts a 6 foot fence in their front yard, right?
So anything over 4 feet.
That's what I,
Okay,
Yeah.
because that's more consistent with where we're at today, right? You can build a 4 foot fence in your front yard.
Was there a reason why we added that? I don't remember that.
I think that the conversation in the subcommittee, if I recall correctly, is that we wanted to not end up having people having to cut down 6-foot fences if they didn't know it wasn't allowed. Or if they put a fence somewhere. So we were going to implement a policy where anybody would have to come in and just get a sign, just saying, here, the fence has to be on my own property. It has to, the posts have to face my property, and here's what will be. And they show where they're putting the fence. That was the conversation,
I think.
the whole section.
Okay. And
Over. Yeah.
Yep.
I think we can, I think we all.
I mean,
agree, yes.
Mike, if
Over
somebody
4
in the township has a 6 foot fence that was built 7 years ago, and now we change our ordinance to require that you have to come in and have a zoning review before you construct a new 6 foot fence, that doesn't trigger that the person who had the pre-existing condition to the new ordinance has to get out a chainsaw and saw their fence down.
Non-conforming structure, right? But subject to the same sort of rules we talked about earlier. So fence is destroyed, fence is abandoned and once it gets
Okay.
wonky, you'd have to then,
That-
if you want
that
to
trigger.
rebuild, yeah.
Okay, all right.
So all I'm doing is adding to that section more than 4 feet in height.
4 feet or higher, yeah.
Yep.
Yes.
I think we need to talk about density with everybody, with at least one you're still. in.
Oh, yeah, it goes
We only have
quickly.
11 minutes.
Time is just flying by.
So.
I can have a
Okay.
game to get to.
This would be 4.
We're supposed to
So,
say one.
I think-
1.
I think the quick one will be doing something.
Well,
Oh, yeah, I don't know what we're doing with Centennial Park. I don't.
I feel like tell me what was changed in this draft Centennial? Can you just go?
Nothing. You guys started to
Okay.
discuss it
we did start.
Yeah, but nobody made any changes. I
Is that-
started
Yeah, I thought that we had talked about, what is the base currently for Centennial?
this. Let me make sure I go to that.
Under our
I
current,
think
under
it's
the current zoning.
When you get there, tell me what page it is.
I'm gonna have to tell you the page based on the paper copy that I have in front. But
Which is dated.
no, this is I printed out a new one just for myself.
Yeah, thanks.
Thanks.
Residential density bonus in the overlays is 7-95.
Thank you.
Section 7.4.
Page number.
795 is gonna be page number 106.
Thank you. Base density requirements in the Centennial Park overlay is 6 units with a maximum of 14 with bonuses.
And what is their current, under the current zoning?
12,
You know, I think it says 20 here, doesn't it?
not for the
that's-
Centennial Park overlay.
Oh,
OC.
yeah, you're right. I see that. Okay. OC.
Okay,
What are you guys thinking?
what's the current again? Sorry.
It's 6 with up to 14 with a bonus.
Being proposed or current as in today?
It's
existing
in
don't-
actual right. that is-
Well,
yes. I just thought that there was some brief discussion at the board, which whatever everyone wants, but I thought that there was talk about keeping it at 12 is the base and then allowing some up to something with bonuses, but that was the discussion at last meeting, but if we don't want to do that, go ahead and talk about it.
So with the pink is what change we talked about, correct?
You know, I
Okay. with
I
that.
feel more comfortable with increasing the bonus and Centennial than I do with some parts of the village.
Yeah, we were talking about Centennial.
Centennial.
So yeah, 12 to 20, right?
So do we want to do 12? I'm just throwing numbers out there for people to talk about. Do we want to do 12 up to 20? Or 12 up to 18? I think that kind of goes around with the Star and the Glenwood is 14 up to 20, so we could do 12 up to 18.
I'm good with that. I would defer to the group on this.
Any thoughts?
What do you think, John?
In that area, 12 up to 14.
12 up to 18, I think is what,
Oh,
or wait,
With the
yeah,
incentive.
12 with up to 18 with incentives, the bonus structure, which would be leaving them at the 12 that they currently are allowed as their base.
I'd like to see
I'm fine with that.
if we. I would feel more comfortable if we pulled back in some other areas maybe, but that's just my.
No, but we're talking about Centennial.
Talking about Centennial.
I don't like but I think they can be looked at separately
Okay.
without being interrelated. But reasonable minds can disagree.
All right,
In thoughtful position.
Thank you.
Sue said yes.
Okay, so,
Yes.
okay, Grace says yes. Chris?
So go from.
It's currently at 12.
Mhm.
So we would keep it at 12 as a base,
Mhm.
up to 18 with bonuses would be the max that they
I
would.
thought it was currently at 6. There was 12 talked
It was
about.
It's proposed,
it's
yeah.
Proposed at 6, I think.
The
those are
current zoning today. is
Yes,
12.
and I think that's where we get some confusion and
By reducing it was to get them to pay into the funds to get more land or to get more pathway.
I don't think that we're forcing anybody to do anything, but I feel like if they currently have 12, that they should continue to be allowed 12. It hasn't been developed at 12, so maybe by giving them a bonus option to get up to 18, maybe it makes it worth it for them to start developing.
I think Centennial
I think that's logical.
is a great spot that can handle it and has the infrastructure and as long as it's, and thoughtful with the incentives.
What was the developer from Centennial saying? What did he need to?
Oh, it was
Like 50.
it was not even in the same,
It
Have
was,
we done like any, Like, I'm just thinking.
It was a
like,
huge difference.
What's the ROI where it does make it worth it to build?
I don't know.
Blanford's did pretty good,
Measurement that
19
I've got-
units.
The measurement that I've got from developers is that if
19
the cost of groundwork has to equate to about $18,000 to $24,000 per unit. So if it costs you $200,000 to do the water, sewer, parking lots, all that stuff, it has to equate to, that has to be divided by, say, $20,000. So let's just use 100,000. So you'd need to have at least 5 units if it costs you $100,000 for water, sewer, parking lot, all of that. So, which 100,000 is
Not gonna get you anything.
not
That
going
would
to
cover
be
the
good.
excavation for the parking lot.
It would be interesting to get the economic data to see what it would actually support.
And look at what we have in there right now. And
I'm
what,
fine with the 12. I mean, I'm just saying, is 18 the right number? Right? If we want to encourage that, should it be higher?
going higher than 18?
I don't know. Like, I don't have data to make
Yeah, I
it,
think
like,
that-
because I feel like we're just,
We're throwing numbers at the wall because we don't really know.
yeah.
Which we can adjust it, but the thing is, you're gonna hear different answers depending on who, if you
That's the
heard,
thing.
Yeah.
if you heard from that one developer, it was,
Yeah.
you're gonna hear different answers depending on the motivations
And I
behind
think
it.
that
And we've done
been
this with,
clear saying to planning staff that we want to see any
Yeah.
proposals that
Yeah.
come forward, that if it doesn't
Mhm.
meet this, we still want to see them to decide if make some adjustments.
because you look at what the density is in existing, it's doable, because it's been done. But if
Mhm.
you listen to the one developer who came from Chicago and his partner locally, they needed it like 5 times higher to break even for profit. So I think this was thoughtfully done by McKenna from a planning perspective, but knowing we will hear different things, like $1,500 a month for rent is super low in Cascade, it's just low. And you hear the market rate going in Kent County, Forest Hills, like, you just hear different information from different people that were in different spots.
Can I walk through a quick scenario? Pretend that we adopt this ordinance today. And we have a development that meets all the standards of this ordinance, but they want a higher density. That's a conversation that we could very easily recommend to that developer. I hear what you're saying. It seems that the board is open to that and they've been open to seeing the ROI on the actual development. So I would suggest that you apply for this and a zoning text amendment to change the residential density from this, you know, and then your development plan will show them the actual fruit of that. That would be my suggestion, is
That's a
adopt
good
this as is, and then we would make that recommendation and you would have a plan and a text amendment that were consistent with the development.
I mean, in the meantime, it is.
Not a PUD.
Yes,
Right, you're right, exactly. And it is, so it's 12 now. It has been for how many years? I don't know.
I think it was changed in 2012, or I'm sorry, 2023
Yeah.
by the planning commission. It was reduced to 12.
All right, so
Reduced that.
they can, they would have to come to the board, wouldn't it? Did it?
It did.
I don't know.
It did.
All right, so is there still comfort to go up to 18 with the incentives?
Sure.
I'm still comfortable with that. I'm fine with it.
Yeah. I'm fine with
Okay.
it.
Nothing happened at 12.
Got it. Base 12,
Eight.
up 18
With
with
bonuses,
bonuses for
and then
Centennial
remind-
Park.
And I think we've heard the direction pretty loud and clear too, that if there's anything in Star, Glenwood,
Yeah.
or Centennial Park that we get presented with, that's open for conversation.
Yeah.
Because again, those are some pretty transitional places in the community that we don't know where that future's gonna go. We clearly know Centennial Park has got a lot of vacancies. So it'll take a creative developer to work with the township, and I think that's something that
Yeah.
that we can orchestrate and bring something before you to consider.
Okay, the village density.
Yes, okay, so I feel bad that Chris is leaving. I hope that you can kind of listen to this afterwards and be able to.
Is there a Zoom?
Yes, there is, yes, so that's good. What we did after board direction was take the previous planning commission tiered system for a base density. I say base now because throughout this whole entire conversation, we've never talked about adding a bonus structure to the village. So this is new. Please, note the language is in here, but that's never been in here before. The base density now is, lots under 5 acres get 2 units. Lots between 5 and 1 acre get 4 units total. Lots between 1 and 3 acres get 6 units total. If you look at the memo, pages,
I think that's what you meant to say.
0.5, yeah.
Yeah, that's zero.
pages
that- that's-
4 through 7 are the updated maps that show you all of the parcels that fall within each of those tiered systems. I also want to point out when we're talking about base density per unit, we're looking at developable acres. So we actually added a reference to developable acres into this section. So that it's very clear that if we're looking at, say, D&W site, which is up on your screens, that's an 18-acre development. If somebody were to tear down D&W, it's 18 acres, but when we do the units per acre, we do not calculate land within the existing proposed right-of-way, wetlands, or water bodies. So if you look at, say, the D&W site with the other associated businesses, that's 18 acres. If we, and this is approximate, but if you were to remove what appears to be about 4.5 acres of wetlands, water, all of that, that gets us then down to 12.5 acres. So all of these density units per acre is based on developable units per acre. So
When I do the math, it looks like we're just under 400 units going
I'm not sure how you did that math
with your numbers right here.
with developable units per acre.
Lots, half acre to 1 acre. You've got 4 units per acre.
Oh, you did the 95, are you talking about?
6, you got 24 of those parcels at 4 units an acre is 96 units. That's just on that size, and you've got this other size here.
Are you comprehending what I just said about
Yeah, I know
developable
you gotta
units
take
per
away for
acre?
roads and all that good stuff, but it still comes out to just under 400 residential units.
Okay, I don't have that calculation.
You got it right in front of you, add them up.
It's not a calculation you can just do off.
Oh, right here.
Okay,
Alright, Scott,
But what are we missing?
I think that you had brought up at the last meeting, potential bonus structure.
yeah.
I did
so-
because what I was aiming for was I liked the bonus structure to have it be
I might.
to be for the owner occupied units. And it seemed like there are parts of the village that I certainly think we could have higher density. And so adding the owner occupied component seemed like a good way to do that. Because I think there are both desires that we have, right? Or at least we have the desire to have we don't want apartment buildings in the village. That's not what we're looking for, right? We want mixed use in owner occupied spaces. So that's why I was saying that. Now, obviously, Timmy points out that, there's some areas here like there's some areas here, particularly, I guess the east side of Cascade Road, where there's a lot of larger parcels and a lot of potential maybe for more units than more than maybe I was going for.
Make sure that's, as we crank it out, because there's a lot of, that's assuming.
You're talking about lots larger than 3 acres and you guys are saying.
But
there's
you
a
also
lot
have to
more.
have, you have to have
There's
side
a total of 9
setbacks,
parcels, that's not.
side setbacks, parking requirements, all these other things that I don't know if you took that into account, because I think that. Is that,
Yes,
if you would, I think if you.
All right, if that's our argument, somebody take it into account and come back with a hard number of how many units I can have.
You just did the.
okay, so you want us to do a
Don't-
land
don't
use
tell me
analysis?
my hard numbers aren't right, their hard numbers are better.
Because again, you gotta have a certain number of parking spots.
Okay,
you gotta
but
have
give me that number.
height requirements, which which probably take the 35 feet.
I'm
to
just
2.
under 400 units, so you guys do your math and
If
come
you're
up, are
looking
you
at-
gonna
if
be
you're
under
looking at-
60?
If you're looking at just acreage and what, density? I'm not a planner, but I'm just saying there's a lot more to take into account that you have to.
Take it all into account and tell me, am I 60, am I 50, or am I 300?
But remember that, so you can't do the Hudsonville style of one giant
Okay with it.
And me too.
Okay,
I don't,
that's-
the consensus is overwhelmingly that we don't want that and that that's why we were so thoughtful and.
But we're not being thought.
For the
No, I know,
purpose
I
of
think we are.
getting
It's just that
some
this is
consent.
separate, there's the simple number crunching, but then there's also the form-based code and they go together.
Yeah, I
There's-
agree.
height.
Exactly. There's so
Yeah, because the
many
height,
pieces.
so this is, you can't just,
Try and get.
I feel like at the last meeting, we.
All I'm asking for is a real number. Take your roads, your setbacks, your sides, your parking spots, all that stuff. Take it off and give
you
me a
have to
real
look at
number.
parcels.
I can, if the board would like me to do that,
I would like a
before
real
the
number.
before the next board meeting, I can take the exact size of the currently existing parcels and give you an approximate number of the max density for the entire village.
Good.
Would the
But
board
I
like me
have
do-
to say though, we're
But-
gonna put this information together
Mhm.
and there's gonna be a disclosure on this too,
Yeah.
that
Yeah.
per the development. This is not gonna be
Right.
like an exact science. That's not how development works.
Exactly.
Yeah.
Meeting, we're coming up with something different for you to go back,
Yes.
just like this, and bring to us, and then we're coming up with a new excuse to move forward, so. I
It's
think
not
that-
that we don't want to, it's just that
No.
there's so many different requirements and when you just say
And I think.
X times Y, it's not gonna be
Yeah,
that way,
next
which is
time.
why we did. Yeah, but you can't, that's assuming you can touch, they can all touch, there's no side setbacks. That's assuming, I don't know what if you're taking into account the 35-foot height, there's all the different things.
And that there's no floodplains, wetlands,
So
existing.
it's not,
proposed
it's not that we're avoiding,
right-of-ways,
it's just that
water
that's not
bodies.
accurate.
Exactly.
It's, yeah.
Which is why at the beginning, the number wasn't, I believe, tell me if I'm wrong, Andrea. The number wasn't in there, which, and I get why, but that was made some people really uncomfortable, understand.
are right.
that.
No,
No,
she's
I'm
talking
saying
about.
the density wasn't in there because there was all the other requirements or
Here, number.
parameters.
Numbers are there.
Which,
there.
hey, Timmy, those were added back in because it made people uncomfortable, which I understand why, but that doesn't mean we took the other stuff out. So if you just look at that, that's a skewed number that's gonna make you think we're wanting to be Grand Rapids and we're not.
I'm just trying to.
I know, but it's frustrating because you always ignore the other part. I shouldn't say speak in absolutes. It seems like oftentimes you forget
Well
or maybe
said.
fail to consider the massive amount of data and information that's not on your chart,
Seems.
which would completely make your chart irrelevant for your numbers.
The
Your
last
work is
board
irrelevant.
meeting.
No, you're
New
correct.
York will not happen. I promise you that New York, Grand Rapids, Ada will not happen with this zoning ordinance. I can guarantee that.
I mean, people have
based
been
on these
clear, we were,
circumstances.
this is, and we're not gonna make everybody happy, you can't, but the goal is to.
So I liked trying it around the area along Old 28th Street and down Cascade Road to Thornapple River and that area, because I look at that as an area where you've got, if you will, a high ridge kind of behind those properties, a lot of trees. And to me, if you're gonna put some taller, what are they, 34, 35-foot high buildings? And, you know, I think that's a good spot for that. So that's why I was really more of a proponent for that. But then it's kind of bled onto the other side of Cascade Road, and then also with the Thornapple Center area, you know, then the numbers, I think, get up there, and that's where his hesitation.
But yeah, if you ignore the other stuff, I think based on what the parameters we have, I think the area we're not talking about that big of an area. Old Cascade Road from the river to say 28th Street, old 28th Street. And then essentially, I think the area that's ripe for potential redevelopment that could be done well and could make a big difference is that following plaza. And I don't know why we would keep it out. And it doesn't mean we open the floodgates for high density or, you know, a huge thing, but I don't know why we would, I think that's an area where thoughtful redevelopment would make a huge difference and it can absolutely handle. I wouldn't want to exclude that.
But you're
My-
giving me numbers to work with, and then you're saying, don't work with those numbers. You're not taking everything into consideration. Well, give me numbers that everything's been taken into consideration. And then I can make a decision. Right now, you're saying, well, there's over 300 units available, but really it's not 300. It's more like 118. I don't know what it is. I'm given numbers that mean nothing. But
Okay.
They don't to you on that one particular piece of paper because a developer comes to us with a site plan that looks at all of the zoning, not a quarter of a page about density bonus. That's,
I'm not going into bonus. I'm just saying these are the hard.
okay,
these are the
okay, just
base-
look at the base, the base density. That's not, the developer doesn't come in and show us section B and go, up, I want to build these apartments or these condos. They come in and they say, according to your zoning, all of the chapters, all of the things, form-based code, density, they then go, they come to us with a development to consider that falls within the parameters of the zoning. It's not one section.
So I think what Timmy's looking for though, is he wants a real life test of that to see how it would,
Well,
what
and,
would
you know, and I'll be
fit,
honest
so
with you
to
too,
speak.
it's really hard for us to go back and make real life sense out of it when every time we have a work
Yes.
session, like you guys are just throwing numbers.
And it's
Every
an
single-
assignment
So,
and some
you know,
other,
I guess we'll go back to the drawing board,
Another
we'll go
rabbit
back and we will
hole.
put together some numbers.
It's another
I thought
rabbit
the last
hole.
board meeting or the last work session, we came to somewhat of a consensus with this village area. And all we needed to do was work on a bonus structure, because
What-
Scott has thrown out
Scott?
wanting a bonus structure.
I did.
And so why don't we get to that point? If we still have consensus that that's where we want to go.
This
Do
is
we have
really,
consensus?
that was to me, that was from when, what, a couple weeks ago, when all of a sudden you guys just threw out all residential in the village area, which was, I wasn't expecting it. It was crazy. We came back from that, but I understand that you just disagree with like inherently what your vision is, but we can't just keep throwing assignments that are like, it's just another, we need to have a real discussion. And the last one was everybody else had a consensus that this was the base. If you want to have, if some, like trustee Rizzi wanted to bring up a post density bonus option, I'm fine with it. I think it can handle it. I think there's parameters in place that protect it from becoming like Hudsonville. But this is just another like throwing something in the spokes because you just don't like it at all.
Here's the thing, you can tweak this ordinance forever.
Yes.
And we've been working on it for so long. You can't know everything that's gonna happen. We're doing the best we can. And so it's frustrating when you keep bringing up new things.
Because ultimately, I get it, you don't want any of this. Or some of it, or no residential, I don't know, but then to just send them on another path of a homework assignment that's not really relevant and just kind of like,
Accomplishes nothing.
we need to have a real talk. So I think, Scott, I would include that plaza area, the foaling, that include it in, I wouldn't exclude it because of all, I think that can absolutely, if done right, is a potential for redevelopment. And would make a huge, which would not only impact the property owners there, but also the community.
Could we walk through maybe just what we want to be included if we are going to implement a bonus structure for residential units in the village? So within your packet on page 8 of 10, section 8.2C is the bonus structure that we put into place. And let's just kind of put away numbers for a minute and say, what do we want to be a potential bonus tool in the village if we do decide to implement bonus structures? What we did was we took the overlay bonus structure and tweaked it for the village. So the first one is Green Space Preservation Fund. All we did with that was took the exact language and said, if a developer would like to develop in the village, they would also be able to use the same structure. And when we write a policy for Green Space Preservation Fund, we will include the village either at a different number or the same for green space preservation. That's off-site green space.
And these are voluntary,
Yes.
I think it's good. Does anyone not want that?
And you can have it in there, I don't care.
You're good with that?
Yeah.
Okay, 2 would be on-site green space. We took that, but we changed it. We actually said that lots under 2 acres in developable area shall not be eligible for that bonus. Just because it just doesn't make sense when we start.
Correct.
So if the board is comfortable with that, we'll keep that on there. That means that some of the sites on Old 28 that already have on-site green space, that's included in their developable acres would be able to maintain their trees and potentially put some residential on their sites.
Okay.
Okay. Ownership, lots under 3 acres of developable area for development where all dwelling units will be offered for homeownership, the allowable density shall be doubled. Shall be doubled the density listed in the subsection above. So that would be, B.
I'm okay with that.
Okay, lots under, I'm sorry, is it the rest of the board, do we have a consensus on that?
And this doesn't waive the other requirements of parking and.
No,
I'm fine with that. Understanding that some people may feel differently, I'm just stating my opinion.
What are you thinking, Scott? I see your mouth moving.
I'm reading it right now. I'm reading further. The lots over 3 acres, it says they will be increased by 2 units per acre, where at least 50% of the dwelling units are offered for home ownership, or by 5 units per acre for developments that are 80%.
Yep.
So if it's under 3 acres, it's doubled
But it's 100%.
yeah, where everything,
100%.
with 100% ownership.
We need to add that. It just says offered for homeownership. I think it should say 100%, just so it reads the same.
say that again.
The 3A, lots under 3 acres for developments where, oh, never mind, it says all dwelling units will be up. Never mind.
It's okay,
We went from percentages to the word all.
sorry. And then if a development, so you guys are, everyone, the board is comfortable with both of those provisions?
Yep. Scott. John. We got
Yeah.
4.
Timmy, do we ask Timmy or do we just ignore him?
Yeah,
Timmy, we want you, your voice matters. Just you might get outvoted.
It's okay to agree with the bonus structure and disagree with the base density.
It doesn't make a
Yeah,
lot of
let's do that.
sense.
Okay.
Directly together.
Because they're kind of along the
And
same.
I don't think there'll be any controversy. This is in for 3C. Same structure that it has to be registered with Kent County Register of Deeds, recorded. Then pedestrian and non-motorized. This is gonna be the same language. I do want to point out that we added in here one sentence just saying if you're required to have this a path, oh wait, that's not the same. We did say if this is a required pedestrian path as part of your site plan, it doesn't count towards your
Good.
density bonus. We didn't have that in there. We added that to both this section and
And not-
7. Just to be clear, it was an administrative decision made based on the fact that it makes sense based on your opinion. Just want to make sure everybody on the board is okay with that. Okay, so same as 7. And then stormwater runoff, decrease in stormwater runoff is also the last bonus that we would add in.
Yeah, we need that generally.
Need that in the village.
Okay, and then anything else that was in 7, we didn't integrate back into this document. It's in your memo without the purple because you couldn't read it. It's in the new document with the purple so that you can read it.
Okay.
So then, those are what we're proposing. I think that based on, Timmy's fears, I can do a land use analysis that would tell you exactly without a perfect number,
As an example, but on the
Yeah.
side, but we still need to
Yeah,
push through this
just
and give.
a
clarity.
total. Because I do want to know, if you look on your screen, I'm going to guess, I have not counted it. But when we say, oh my goodness, this could be 300 or 400 units per acre, if you look at the other side of the Thornapple River, this entire residential area here is probably around 300 or 400 residential units. I didn't do the math, but I don't think that that's as scary as a number as we may, I don't think it's that scary. I can do the math though. So next meeting, at least we'll have it in front of you if you want to tweak the numbers.
I just feel like sometimes
Well,
just gonna be more discussion.
yeah, so.
Yeah,
Do you have any
I agree.
recommendations or are there any recommendations for, what are you looking for, a range? What would we do, like we did in Centennial? We're up to?
so
No, I think
what we
Just how
put
it
in
is.
there is just
Type of developer.
base of 10 units per acre. So it's 6, it's between 2 to 6, but based on the size of your property. We're saying just 10 units
Okay.
would be the max, which is not clear if it would be physically possible based on our height.
Not clear if it's possible, but I think that's smart.
That'd be my recommendation.
Scott, thoughts.
I didn't hear that last part.
we were talking about what the max would be with the bonuses, correct?
Correct.
Up to 10. Depending on the lot.
So within, at the beginning of chapter of 8.2C, the density limit described in subsection B may be increased as described below. The actions below may be combined up to a maximum of 10 units per acre.
And-
All residential density in the overlay shall be calculated using developable units per acre as defined in section 6.3F, which like I talked about, takes out wetlands, takes out right of ways, takes out water, bodies of water, steep slopes.
What would it be today, in today's ordinance?
I was just gonna ask.
What would the
What's
density
units
per acre?
Yeah, I mean, if somebody came in and they got a,
By
1.5 or 2 acre site and they wanna,
I think it's 9.
Nine.
Let me pull it up quickly. I'm pretty
Nine.
sure it's 9
Around that.
with special use.
But there's a problem. We're vulnerable
bonus.
right now on our current zoning for all the lack of our current zoning. You could have someone come in, do 9 units per acre, no incentives, and then
Yep.
push out all the commercial because residential's hot, and then you get a bunch of, like, I don't think we don't,
right, because now we're gonna require a retail or commercial aspect component to whatever you do, which currently technically we don't require in the current zoning.
and people will pay a lot for new, like, you could have a bunch of apartments in that, plaza area under our current zoning.
We already do.
Townhouse
Maybe not.
That's what
with
I thought.
garages.
Garages.
Yeah,
Yeah, the current ordinance, as it sits right now, says residential, over 3 dwelling units per acre, but less than 9 dwelling units per acre is allowed with a special use.
okay. Well, 10's more than we have now, so.
Is allowed by.
I think that I'm very comfortable with that.
Are there any other pieces?
No, there was, and it's all in your draft, but we did take a section of chapter 6 and just moved it from what the calculation for subdivisions. We just moved it up and made it applicable to the entire zoning ordinances. Which is why I keep on talking about developable units per acre. Because we just did that across the board, so it would really just decrease the number of units you can use.
No matter where.
Yeah, so it's a consistent measurement across the board. So anywhere that it was referenced in the zoning ordinance, we changed that.
Yeah, I just think it's important to remember that what we've got now and all the problems with it, even if it hasn't happened yet.
And we continue to have applications, I have emails in my email box right now saying, when are you gonna adopt? Do I need to hand in this application? When can I be heard? I wanna utilize the new tools, or I wanna utilize the old tools. So it's putting a strain on the development department, just on the community development department, with us not adopting. Because on a regular basis, we get phone calls, and on a regular basis, we say, you can either apply today under these rules, or maybe these will be the rules and you can apply tomorrow.
Does anyone, so the proposed language that we just went over that caps it at 10, I believe? Comfort level at the board to keep that in the proposed draft?
I'm comfortable with that.
Me too.
Which one are you talking? It's the one we just talked about, basically 10, but it doesn't ignore all the other things, like you still have to, you can't just combine.
Of course, that's only good for 5 years, and they have to live they can change it out to rental after 5 years.
I don't remember.
So,
Yes, that's what it says.
yes, that's true, but it wouldn't usually be then one owner of a whole building, because at that point, when they develop their building, they would be setting up their utilities. Its structure, those would be sold. So they would all have different owners. If someone wanted to rent it, it would still be set up for one person that owns one unit to rent to one other family. If that makes sense.
Can I bring up another item that I think we didn't get to on October 8th? On page 6-84. Section 6.7F. Hold on, let me get there.
What's the page on the computer?
I'm
This is in
finding
relation
that, I'm finding.
Purchase of development
Page
rights.
95. 6.7F, and I don't think we got to this, but I could be mistaken. It was in the memo for that meeting. The chart. I think Andrea had proposed a different chart that was structured a little bit more favorably to entice people to want to preserve land. Whereas this chart maybe wasn't as, I think this one starts at 0, and I think the proposed one, if in the memo started at, if I'm not mistaken, 20 maybe.
I believe so. I'm waiting for my computer to log that. Do you remember the date of the memo?
10-8 is what my notes on the October 1st copy say.
So as a reference, this section 6.7 of the zoning ordinance as or 6.7, purchase of development rights was I don't want to say boilerplate, it was built for us, but it was a draft purchase of development rights ordinance provided by Foster Swift, where they kind of boilerplate threw in the acres, the size of the acres, but didn't really do the land use analysis on how many parcels we have of what size acres in the township. So we took the draft purchase of development rights ordinance, put it into our zoning ordinance so that everything is encompassed. And Scott had actually suggested that we lower that a little bit. I did do a little bit of number crunching to figure out how many parcels met what size. The goal with this carve out in section F of section 6.7 is to allow someone that might want to utilize the purchase of development rights for a large lot to carve out for their family. So say they've owned the property their entire lives and it was passed down to them. They want their kids to be able to build a parcel. And then they want to sell off the development rights of the rest of that. So that they would be adding one parcel next to a home, and then they would through conservation easement preserve the rest of that land, and we would buy those development rights. That's what this section is talking about. So the tiered system, what was it? My computer's up now, Chris. I'm sorry, Scott. What was
It looks like it was
memo?
page 5 of the memo.
What's the date of the memos?
The date of the memo is
8/25,
And this is,
No,
just to
it was
clarify, this is
10.
the.
10-3.
10/3.
10-3 is when you emailed it out.
This is a completely voluntary tool. It's nothing, this is,
It's not
Right.
forcing anybody to.
no, this is 100%
Yes,
a
yes.
voluntary tool available to homeowners so that people, an option to keep farmland in the family or,
I think the proposed, that's the proposed chart. That's what
So-
I was looking at too.
Yeah, if you toggle, here's the memo. So what Scott is discussing is just changing that chart, which right now says 0 to 40 acres gets 0, 41 to 80 acres gets 1 of those little carve outs for the family, 81 to 160 acres gets 2, and 160 and over gets 3. So I just kind of took the number of parcels that we actually have in the township and applied those numbers to our existing situation. I don't think that would be onerous. That is a new section, so.
It kind of gives you more at both ends of the chart, but it's not giving away the farm, so to speak. No pun
I'm
intended.
fine with that, whatever you, yeah.
But it gives you nothing for the first 20. But if you have a larger, area, 20 to 40, you get 1. And on the other side, the old chart was 161 or more acres got you 3 points. And here it's 80 acres or more, it gives you 4 points.
Mhm.
So it's just, I think this is a little more realistic compared to what we had before.
Mhm.
So that's all. And she spent the time to put it in the memo, so I wanted to make sure we got to it.
Mhm.
It's not in this one. No, it was in the previous, was one of the previous work sessions and we ran out of time. We didn't get to it. So I was going through my notes, trying to see what we've missed in previous work sessions. And that's part of what I brought tonight to try and.
Does that make sense to you, or is there something we're missing?
I don't think it would be unreasonable.
Or
If
something
you
we're not
feel
taking
like
into
it's
account?
too generous, you could get rid of the 80 or more and make everything, just 60 or more would be 3. But I don't think it would be unreasonable or impractical for what we're trying to accomplish.
Okay.
Again, everything is voluntary.
Mhm.
It's still just providing for families to be able to keep their farmland farm and provide for their children.
Partnering with the county with that existing program. Okay.
So I don't, if the board would like, I can integrate that new chart into that section of the ordinance.
That'd be nice. I'd be good with that.
Mhm.
I had one last question, I think. 8.388. I had asked a while back, I asked a question about knee walls. And the answer in the memo, and I don't remember which meeting it was, might be the same memo you have up right now. And it asked if knee walls could be in the right of way, I think, or not, and I think your response didn't, I think there's confusion.
Right.
So I'd have to look back and see where that is. I don't have.
What's the concern?
I'm trying to remember now. I think I had asked if you can construct knee walls within the right of way or not, or within the setback or not. And I don't think the answer, either I didn't word my question right or you didn't answer clearly. I don't remember which way it was. So my question is, can knee walls be in the setback?
Yes.
And if they can, I think we should make sure it says that in the ordinance, because I don't think it's clear about it.
So.
The only reason I'm bringing this up, I don't have a specific agenda here. It's just, I don't want staff in the future to be confronted with confusion.
I
from the-
remember us having this conversation, and you can have them in the setbacks because part of the reason you do some sort of knee walls, and like you use our DDA as an example, those are considered somewhat of a branding streetscape down the
Yes.
corridors. You're not gonna put those 20 feet back off the road. You want those up by the sidewalk to create that consistent look.
Okay.
So yes, they can go in the setback,
Does it need to
but not
say
the
that?
parking behind it.
No,
This,
Okay,
it doesn't need to say, so
okay,
we also have section 4, I think 21 now, that handles walls and fences. The height of a knee wall is the same height, maximum height for any wall and fence, and those are allowed up to the property line. So it's already allowed. We don't need to say that it's allowed when it's allowed.
thank you for clarifying.
I'm feeling particularly wonky today. Anything else?
Anything else in addition to, like, any other direction, questions? Clarifications?
are we still bringing this forward next week? Okay.
With the, as discussed with
Yeah.
this.
Okay.
And just to clarify, will those changes all be made then before that?
Incorporated.
that's
the
your
proposed
choice.
Draft.
I think
Yeah.
that would be easiest for the resolution.
Absolutely.
So then the resolution will say that you're proposing the introduction of of
This.
zoning
that-
ordinance dated.
Okay.
And I can change those couple things and then it will be dated 10/28. And we can still have with amendments, so within your resolution, you'll still have room to make any amendments that you want to. But that way, the next version with these things integrated into them will be provided for the public in the packet that goes out this Wednesday for the following Wednesday's board meeting. And everyone can look at it and we'll update the website.
Can we just hit on just because there's been questions, or I guess not even questions, statements or concerns about it, that private road requirement, which I didn't realize that had already been changed previously, but not enforced. Is that fair to say that?
Yeah.
Which private road?
So there
requirement?
was some concerns about the standard and
Mhm.
adhering to the county standard. The county standards are in our current private street
One that
ordinance
we have right now, not.
right now today.
Yeah.
I can't answer to what happened 5, 10, 15 years ago when people were allowed to put them in and didn't have to adhere to that standard. The actual standard of the road is this exact same language. We've confirmed it with the county and it's in there. The only thing that changed in the private street ordinance, I shouldn't say only, but the biggest change in the private street ordinance is the width and the number of homes that can be on a private road.
But it's still
But you're-
private roads. It's not, the initial discussion was turning them over, like just
Yes,
shared driveway, no private roads. And
because it meets county standards does not make it a road. Meeting county standards is meeting county standards in regards to the construction of the driveway, pathway, whatever you want to call it. You could put that standard in place for anything, but the standard is still in place.
And we've. The initial discussion of making all additional future roads like up to the county and turning over to the county, we didn't do that. They're still.
Correct.
a Private street.
Correct. Then I think we increased it to
8.
8,
8.
I believe it's 8.
But it's still allowed.
No, I'm sorry, the width.
Oh, the width, would we go to 22 feet?
22.
Yeah,
Which is less than what the public roads would be, correct?
Yeah.
Right, I believe they're at 30.
I think
if I'm
that's
not
right, because
mistaken.
11, yeah.
I think that's a good balance because then you've still got all the,
I mean, and that doesn't mean that someone can't make a private road that's 30 feet wide.
no, not at all.
Right,
Well, I guess it is. Our zoning prohibits it. Never mind. Forget I said that.
But it should be on the developer who's making making the road for profit to bear the cost of doing it better than just a driveway versus the residents who buy into it. And then after a couple years, they've got a subpar road and not enough association fees and the township is left. And that township means existing residents' tax dollars, because everything the township does, time, energy, everything is paid for with tax dollars. It makes sense. All we're doing is holding the for-profit developer, they're still allowed to do it, but they need to make sure that their roads can last a little bit longer versus sticking it with us, the other taxpayers, to fix it down the road. I think that's
correct.
And that's
a
where
good
it's
balance.
important. And then it's where the maintenance agreements come in.
Yes.
Where there's standards now to these maintenance agreements that need to be adhered to.
Mhm.
And that's not any, like, every developer that I've worked with on these private roads, if you require them to do this, they'll do it willingly and they're compliant happily. And they understand that that's gonna be the standard of development. It's not, a new responsibility that any developer is complaining about. They understand that if they're building a residential development, that people want a road they can get to their house on, and they want to know how it's gonna be funded. We're just making sure it's done for everyone's benefit.
Right. And if you allow people to cut corners, they're gonna cut corners, just human nature. And for some reason, whatever reason, we didn't even enforce what we
Well,
had.
And when you bring in public safety and you bring in emergency response vehicles too, those standards have to be met so you can get a fire truck turned around.
And those were not being tested. Those were not even being
Correct.
tested. I don't see how you can have a high density residential like the behind Culver's on a private road like that shares the entrance with a fast food chain, but we won't do it anymore. That was one of the things that we wanted. That's an example of what not to do. All right, anything else? Because we gave good marching orders. Ready to go. Want to fight about anything else?
Thank you for all the insight and direction today.
Thanks for sticking with us. Okay, is there a motion or further discussion?
Make a motion to adjourn. Support.
That's a motion by Clerk Slater, supported by Treasurer Corstange to adjourn. All in favor?
I.
Opposed? Even Shipley didn't oppose it tonight. We are adjourned.